The chair now calls the second panel. The chair welcomes the second panel to the desk and to this hearing. The chair apologized for the inconveniences that you might have had to endure while we were on the floor voting. And the chair is very respectful and appreciative of the fact that you have come from far and wide to be here to testify. I want to introduce our witnesses, and I'll begin on my left. Ms. Gail Hillenbrand is a senior attorney and a manager for the Financial Services Campaign for the Consumers Union. Seated next to her is Mr. Stephen Calkins, Esquire. He's the Associate Vice President for Academic Personnel and Professor of Law at Wayne State University. Next to him is Mr. Prentice Cox, who's an Associate Clinical Professor of Law at the University of Minnesota. And seated next to Mr. Cox is Ms. Rachel E. Barkow. And Ms. Barkow is a professor of law at New York University School of Law. And last but not least, the gentleman with the smiling face next to her is Mr. Chris Steinberg. And Mr. Steinberg is the president and CEO of American Financial Services Association. We want to thank you and welcome you to this committee hearing. It is the practice of this committee that we swear in witnesses, so would you please rise and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? I do. Let the record reflect that all the witnesses respond in the affirmative. Now it is my privilege to allow you to recognize you 5 minutes for an opening statement. So, Ms. Hillenbrand, we'll start with you.
Thank you. Chairman
Yeah, turn the mic on and pull it close to you, please.
Thank you. Chairman Rush, Ranking Member Radonovich, and members of the committee. You know Consumers Union as the nonprofit publisher of Consumer Reports, but our mission is to test, inform, protect, and empower consumers. And that's the role in which I appear before you today. My written testimony was joined by 6 national consumer organizations. Consumer groups want, and consumers in the U.S. need, a strong consumer financial protection agency, a robust Federal Trade Commission, and a strong role for states in consumer protection in financial services. We believe that those goals are entirely consistent with one another. The goal is a better financial services marketplace and better government in financial services oversight. We have to face it. The current system doesn't work. It's not delivering products or encouraging products that are understandable to consumers who use them or that meet the reasonable expectations created in the sales process. Instead, we have gotcha banking. We have multiple regulators by type of provider, even when those providers are competing directly for the very same consumer. We have long delays for regulatory action. And we don't have much of open public enforcement except by the FTC. And finally, we have abusive features in products that are squeezing their way through the holes in the existing law and the existing regulatory scheme. I believe the job of government is to serve the people. We're not here to talk about more government. We're here to talk about better government in financial services oversight. Today, our system just isn't designed to do the job. It's spread out over 6 or more agencies with a hodgepodge of rules and statutes. And how much enforcement a provider receives depends in part on who its regulator is. That is just not a system designed to match the realities of today's market. We want to give the federal government a different and new job in financial services marketplace, and that's to promote a fair as well as an efficient financial services market, to watch for the market to prevent harms as they start to develop. I come from the great state of California, where the option arm and some of the other products that have gone so terribly sideways were pioneered. And you can only wonder if someone had been watching those markets more closely, whether that would have spread around the country. The mandate of the CFPA is the right mandate, is to promote transparency, simplicity, fairness, with accountability and access. And notice I say promote. It's a different job from what the federal government has had before. And with the CFPA, we have the opportunity for an agency that has an obligation to get information, to learn about the market, to watch that market, and then to make a conscious decision about what needs to be regulated and what doesn't, and which regulatory tools to use, and then to apply those tools evenly no matter who's providing the product. With the CFPA, we could get one agency to watch over the market, faster acting responses, one agency that's responsible to you and to me when things go wrong, and one place for your constituents to go instead of the alphabet soup they have now of trying to figure out who to complain to and who to get relief from. The CFPA model is one federal rulemaker, but multiple enforcers. And that brings me to the incredibly important continuing role of the FTC. I'd like to disclose, Mr. Chairman, I was once a summer law intern at the Bureau of Competition at the FTC, longer ago than could possibly be relevant for today, but I want to disclose that. The FTC keeps its enforcement authority. It keeps its Section 5 authority with a simple, regardless of the topic, financial services or not, with a simple consultation that can be at the staff-to-staff level. It keeps its authority with respect to all the statutes it now has with that referral process. And I think it's very important to note that's a refer and wait process, but they're not waiting for a yes or no. If the CFPA does not take on a case the FTC thinks needs to be brought, it can still bring that case. The CFPA cannot say no. We have made a recommendation to you in the written testimony that the statute should allow the CFPA to waive that notice or to shorten it by individual case, by type or category of case, and by agency, so that they can work these things out where there's commonly, for example, the telemarketer case with the EFTA claim. And we also are recommending to you that the FTC be given the authority to be a secondary regulator with respect to enforcing the CFPA rules, not writing them, but enforcing them. The FTC does lose jurisdiction to write unfair and deceptive acts and practices rules in financial services, but that has not been a role they've been able to use widely in the last couple decades since the credit practices rule, which went into effect in the 80s. They keep all of their enforcement, and of course it will be made stronger with the aiding and abetting enforcement. We believe this is the only way to put all the competing products under the same set of rules. I have some examples, but I'll hold them for the Q&A because I'm conscious of your time. And I do want to say that I think it's very important what the FTC does right now in the recession. It's very important what the FTC will continue to do after the transfer of authority in those cases where there's overlapping enforcement, and it will be extremely important what the FTC does with its additional authority. There are a lot of things the FTC can do right now to help consumers who are suffering from the recession, including cleaning up the problem with credit reporting errors, the work it's now beginning to do under the new authority you gave it on mortgage modification and foreclosure, debt collection and debt settlement. All those things will remain extremely important. I'd be happy to take questions. Thank you.
Thank you very much. Mr. Calkins, you're recognized for 5 minutes.
Thank you. Chairman Rush, Ranking Member.
Would you pull the mic closer to you, please?
Yes, sir.
Thank you.
Is that all right?
Yes.
It's not on.
It's not on.
Push the button.
Push the button. Thank you. Special thanks for the technological advice here. Chairman Rush, Ranking Member Radonovich, members of the subcommittee, thank you for inviting me here to testify about this important matter. The proposed legislation would affect sweeping changes in the Federal Trade Commission. The key to the bill is in the definitions, and they are written extremely broadly. Applying those definitions and working your way through the bill, you find that the bill would transfer out of the Federal Trade Commission much of the work that the Federal Trade Commission now does, giving those responsibilities to the new agency and giving it the exclusive authority to prescribe rules and issue guidance with respect to much of what the Bureau of Consumer Protection does. If you take the FTC's most recent annual report for 2009 and turn to consumer protection and start reading what they have been doing: subprime credit, mortgage servicing, foreclosure rescue, fair lending, mortgage advertising, debt collection, payday lending, Operation Clean Sweep, Operation Telephony, the Synthesia marketing case, payment systems, the Neovi case, Nationwide Connections case, global marketing case, and so on and so forth, prepaid phone cards, on matter after matter after matter of what they have been doing. I read the bill as saying that all of that would be transferred to the new agency. In short, we would have major change. Indeed, if you read the bill carefully, you would find that even some of the antitrust responsibility of the Commission would be transferred. I assume that's a mistake, but that's how it is currently written. Now, why have this sweeping change in what the Federal Trade Commission does? It might make sense if the Federal Trade Commission was a bad agency that was doing bad work. But as you all have spoken so eloquently this morning, the Federal Trade Commission is a good agency that has been doing good work. It has a unique bipartisan structure. It combines consumer protection and competition to bring the best from both perspectives to bear on problems. And it has been doing important work for consumers, including in the world of credit, for a very, very long time. Transferring responsibility from the Federal Trade Commission to another agency obviously creates some pretty significant risks. And my recommendation to you is to proceed with great caution, to weigh those risks, to decide whether they're really worth running, and certainly if they are, to work very hard to try to minimize those risks, because the bill as written would make major changes, and you need to be very careful to make sure that all of this makes sense. Thanks very much, and I'm happy to answer questions when the time comes.
Thank you. Mr. Cox, you're recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member Radonovich. Oops. Thank you, Mr. Chairman and Ranking Member Radonovich. Abuses of consumer finance products were a disaster for millions of consumers before anyone recognized them because we had a financial crisis. A disaster. A previous testimony about someone committing suicide. I sat with people whose families committed suicide after I worked with them, who had heart attacks from the stress. Millions of people experienced this. Our federal regulatory system did not respond to this. It was dominated completely by the thinking and needs of the lenders and sellers, and not by what was happening on the ground. It is often said that no one could have seen this. The people who were working with the victims of subprime lending and were talking to people who reflected the experience of those people, as well as the others who were subject to the abuses of consumer finance products, absolutely knew what was going on and were screaming at the top of our lungs. No one was listening. It was predictable and it was preventable. The Consumer Finance Protection Agency, as proposed, offers the first hope in generations, certainly in my adult lifetime working on these issues, for an agency with sufficient power and focus on consumer protection issues to seriously address these problems. It gets it right in terms of its model. It sets up a unified rulemaking process. It's not about whether the FTC was good or bad. It's about the fragmentation of authority and the lack of perspective in a unified rulemaker. It gets it right in setting a floor and allowing innovation where innovation should occur, which is in the state regulatory system. And it couples that with an open enforcement system. It allows the enforcement of those clear unified rules to occur in multiple places, and there are two reasons you want that. The first is that you can pair the proper enforcement agency, public enforcement agency, with the problem at hand. If you've got a problem that just occurs in Indiana, the Indiana Attorney General is the right place to do it. It simply won't get taken care of if you allow a federal agency. Conversely, if the Indiana Attorney General turns up a problem that appears to be nationwide, that can highlight the need for the agency. Secondly, the Agencies like the FTC and state attorney generals often will bring violations of rules ancillary, which is what Chairman Leibowitz was saying, ancillary to other investigations because these things don't come up in little neat silos. So an open public enforcement model, which is what this bill has, by allowing the Federal Trade Commission and other federal agencies to enforce the rules, and state attorney generals to enforce the rules, enhances enforcement. I will make two quick comments, one about the details of the enforcement mechanisms and the other about the rulemaking investigative authority. The open enforcement mechanisms in the bill are excellent. However, I agree completely with Chairman Leibowitz that the 120 days restrictions on the FTC is way too cumbersome. It needs to be streamlined and made more efficient. Secondly, and this is, I think, is a very important point, in the bill as currently constructed, the FTC is given the authority to enforce extant federal consumer credit laws, but not the regulations passed by the CFPA. The CFPA regulations over time will become much more important than the extant consumer credit regulations. It's really critical that the FTC get the authority to enforce the regulations that are passed by the CFPA. There's also a consulting power in there. Requirement, and that's correct, and I hope that on an informal basis, the agency takes account of the fact that the FTC, which enforces UDAP, Unfair and Deceptive Acts and Practices laws, gains a particular type of experience and understanding that's vital to setting those rules. Secondly, state AGs have authority, but that mechanisms for remedies need to be clarified because right now the Section 1055 powers, it's unclear whether those are bootstrapped into the AG enforcement. Finally, in its rulemaking authority, the new CFPA desperately needs detailed and express and clear investigatory powers. Otherwise, the data that is brought to bear and what the rules are will be data held by the industry that the CFPA simply doesn't have access to. So it's critical that the CFPA have that investigative power so that they can get the rules right the first time. I really appreciate the opportunity to be at this historic hearing and wish the Congress great luck in making this project work.
Thank you very much. Ms. Barkow?
Thank you, Mr. Chairman, Ranking Member Radonovich, and members of the subcommittee. Thank you for inviting me to testify before you today. I'm honored to have the opportunity to discuss this piece of legislation. The linchpin of the Consumer Financial Protection Agency Act is, of course, the agency it creates. So whether this act will succeed or fail in its mission to protect consumers will depend entirely on whether the agency it creates will succeed or fail. I've therefore analyzed the structure and powers of the proposed CFPA to determine if it has been designed in the most effective way to achieve its stated statutory mission. I take no position on the merits of that mission or whether there's a need for a new agency to regulate this field. Rather, my focus is on whether the CFPA has been designed as effectively as it can be to achieve that mission. In that regard, I'd like to make 6 brief suggestions and observations about the design of the CFPA in this legislation. My first recommendation, and the most important, is to add a provision to this act that would limit the CFPA board's membership to no more than 3 members of the same political party. Unlike virtually all other legislation that governs multi-member independent regulatory agencies, including the FTC, the SEC, and the Consumer Product Safety Commission, the CFPA Act, as it's currently written, does not require political balance among the agency's membership. There's a wealth of empirical studies that are demonstrating that a group comprised solely of ideologically like-minded people tends toward extreme decision-making. Without a provision in the CFPA Act requiring partisan balance, the CFPA is likely to change positions from one extreme to another with each new presidential administration. This is unhealthy for the regulation of any market, and certainly the consumer financial products market. A political balance requirement can serve as a stabilizing force. In addition, a political balance requirement can lead to dissenting opinions, which is valuable for alerting Congress and the public if the agency goes in extreme direction one way or the other. Second, I suggest amending the Act's requirement that the CFPA consult with all federal banking agencies and any other relevant agency before passing rules to make sure those rules will be consistent with the prudential, market, or systemic objectives of the agencies being consulted. Because this consultation requirement sweeps so broadly, covering every conceivable agency regulating related fields and anything of any importance to those agencies, this process is likely to dramatically delay the promulgation of CFPA rules. This is precisely the kind of requirement that aids industry participants in tying up agency rules for years. So unless Congress is of the view that the delay in legal uncertainty is outweighed by the benefits of this provision, I suggest making clear that consultation is at the discretion of the CFPA and not subject to judicial review. Third, I advise modifying the statute of limitations provision in the Act to begin running from the time the CFPA discovers a violation, not from the time a violation has occurred. Because violations by sophisticated business interests are not discovered for years in many cases, this provision as it's currently written might hamper the CFPA in its enforcement efforts. Fourth, I recommend including a limitation on the ability of CFPA board members to practice before the CFPA for a period of time after their service on the board has expired. This kind of restriction would limit the negative effects that are often caused by having a revolving door between agencies and the industries that they regulate. Fifth, I just would like to highlight a protection in the Act that I think is going to be critical to achieving the Act's law enforcement objectives, and that's Section 1042 of the Act, which allows the state attorneys general to enforce the provisions. State AGs have demonstrated in many areas that they can be effective law enforcement partners, and I think this is particularly true in the area of consumer protection, where agency capture is a significant risk. Finally, I'd like to alert the subcommittee's attention to the fact that it's unclear from this Act as it's currently written whether the CFPA will be subject to presidential directives and oversight, including review by the Office of Information and Regulatory Affairs, known as OIRA. There's language in the Act that suggests this is actually going to be an executive agency and will be subject to this kind of oversight. Congress may intend for the CFPA to be part of the President's oversight process, but if not, the Act would need to be rewritten to make clear that the CFPA is an independent regulatory agency for purposes of OIRA review. I take no position on whether or not the agency should be subject to this type of review, but because it's a fundamental question, I note for you that it's currently unclear in the legislation. Thank you again for allowing me to testify and share my thoughts on this proposed legislation, and I'd be happy to answer questions when we're all done speaking.
Mr. Steinberg.
Well, thank you, Mr. Chairman, and thank you for this opportunity to speak with you today. I'm very glad to hear that this is kind of a first step, and hopefully which will be a long process, because as many have expressed here today, there are certainly some concerns about this issue, and we hope that there will continue to be somewhat of a cautious approach as we go forward. The American Financial Services Association has been around for almost 100 years, and we represent about 30% of all consumer credit in the U.S., with members in the mortgage, credit card, auto, and personal installment loans. First and foremost, AFSA supports strong financial consumer protection regulation. Just because we have concerns going forward about the current agency does not mean that the industry and that the association is not committed to strong consumer protection regulation regarding financial services. We believe that consistent enforcement of existing consumer protection laws by government regulators would have greatly lessened the harmful impact that the current crisis has on consumers and certainly our economy. Many AFSA members are regulated primarily at the state level and subject to a patchwork of requirements. We firmly believe that consumer protections should be uniform in every state. Therefore, AFSA supports strong national consumer protection standards that allow the members to meet their consumer protection obligation in an efficient and cost-effective manner. In addition, strong national consumer protection standards will provide a benefit to consumers only to the extent that they are consistent with sound prudential regulation. Consumer protections that threaten the safety and soundness of financial service providers offers real no protection at all. We believe consumers will be better served by a regulatory structure where prudential and consumer protection regulations are housed within a single regulator. Congress tried to separate these two intertwining functions with the GSEs. When it became apparent that this situation was unavoidable, Congress brought the two regulatory functions back under a single regulator, and for good reason. We urge Congress to support regulatory structure that does not separate safety and soundness from consumer protection. The authority proposed to be vested in the new agency is breathtaking in both its scope and its effect. It would cover many entities and persons who have little or no involvement in the activities leading to the current economic crisis. Without any demonstrated need, many unsuspecting persons will be swept into a web of scrutiny and reporting requirements that yield little in the way of consumer protection, but much in the way of increased cost for consumers. Attorneys, accountants, consumer reporting agency, auto dealers, title companies, among others, will find themselves subject to review with no evidence that they behaved unfairly. Financial service providers will find it increasingly difficult to plan for risk, as virtually any practice or product other than prescribed, standard, plain vanilla products could be labeled as unfair or abusive. Innovation will be discouraged. Given the vast scope of the proposed agency's authority, its funding needs are also staggering. The proposal seeks to fund the CFPA by assessing fees on persons and entities it regulates, while including many that would not expect to be covered currently. There is no doubt that any assessment on financial service products will be passed on eventually to consumers. That direct, unavoidable result will be an increase in the cost and availability of credit. Most AFSA members are regulated by the FTC, which has a proven record of enhancing consumer protection. It has addressed the economic crisis in two ways. First, by using the enforcement authority to pursue bad actors in the financial services industry, and second, by setting federal policy through guidance and public comment. Numerous examples are listed in our written testimony, but in conclusion, AFSA believes that the FTC has done an excellent job in enforcing consumer protection laws and is best suited to continue that role going forward. We believe the administration's goal can be achieved with adjustments to the current regulatory structure, and the result will be more efficient, less costly, and certainly more effective. To that end, we have two specific suggestions. One, make current and future consumer protection rules apply to all financial services providers. Congress should ensure that all federal consumer protection laws and regulations apply with equal force to all providers of financial services with respect to similar cases of products and services. These laws should include strong national standards that preempt state laws and permit all Americans to enjoy consistent level of services and access with respect to financial products and services. We've heard again and again and again today, as you have 50 different states that can exceed or meet or exceed the current laws, this is not simplification. We're just going to wind up with 51, as you stated, Mr. Chairman, 51 different rules that these people are going to have to follow. And number two, pursue a regulatory structure that does not separate financial products and services from the viability of the companies that offer them. All prudential agencies should work together to coordinate consumer protection regulation for financial products and services, with the goal that regulations be preemptive, consistent, and uniform. If we don't have that, we're not going to make any headway. Thank you for your time.
The chair thanks the witnesses.